On behalf of Wealth Counsel, I would like to welcome you to our Thought Leaders Series webinar on adding business planning to your estate planning practice, led by Jenny Villier, Heather Satin, and Patrick Carlson.
Thank you everybody again for joining us. Here is our overall agenda for today's broadcast. And so what I'd like to do now is just kind of jump into the content and really move into the discussion about why you should even be considering adding business planning to your estate planning practice at this point. So I've shared these 4 general points about why you might want to consider adding business planning to your estate planning practice. So let's dig into each one of them and kind of unpack this a little bit. The first one is, I think we have to really consider what something is before we can really talk about why we should be doing it. And so here I've shared what you might consider to be a working definition, if you will, of the service that we could broadly describe as business planning. And so really it's about using legal tools, and these are just our business entities, contracts, lawsuits, other things that we know as lawyers to really support our clients' goals and needs, while also leaving the door open to taking advantage of opportunities in the future. Now, I know many of you on the call today are estate planning attorneys, and this is really distinct from the way that we use a lot of these things in estate planning. Estate planning does use a lot of these same tools, right? We've got entities, we've got LLCs, we've got corporations, we're going to work with partnerships and other things. But really the way that we use those in estate planning has a different focus, okay? In estate planning, we're often concerned again about that, avoiding court control, passing assets to intended beneficiaries, reducing administration costs. We're really concerned about transfer tax savings, things like that. Recently, there's been an increasing trend for income tax savings and things, but that's a more recent trend since ATRA and then again the tax reform last year. Again, bottom line, that's a gratuitous type of purpose. On the other hand, business planning is really more about profit. This is about facilitating profit for business owners, so using the law as a tool to help them do that. So it's much more about tax reduction. It's much more about litigation avoidance, risk management, asset protection, in the sense that it's not we're worried about a lawsuit unrelated to the activity, we're worried about a lawsuit directly related to the activity. And so I think when we have that backdrop, it can help us understand some of the differences in the way that we would need to think about these services, the way we would conceptualize the value that we're offering the clients, and ultimately the way we're going to work and market to them. Again, one of the big reasons that a lot of lawyers are considering this is, of course, because of tax reform, such a huge opportunity. It was really the biggest change to our tax laws in 30 plus years. And it was particularly significant as it relates to the taxation of business owners. We have the new Code Section 199A with the qualifying business income. We also had a reduction in the C corporation tax rate. One of the stated goals of Congress, of course, was to drive economic growth and encourage business ownership and really encourage business expansion. And so any type of increase in those areas is going to likely see an increase in the need for legal, accounting, and compliance work for these types of businesses. And so businesses that are wanting to manage that risk, businesses that are wanting to grow and expand, take advantage of the opportunities under the new law, they need your help. And that's one of the reasons this is such a fantastic opportunity for attorneys that are interested in expanding into this area. The other reason that you might want to consider adding business planning to your practice is diversification. I think it's fairly safe to say that if you're a business that only offers a single service, you're at a greater risk than businesses that are offering a broader scope of services. And that makes total sense, because when you only sell one thing, say estate planning, you're at a much greater risk to changes in market condition for that thing. Now, the other reason here is that it lets us diversify our revenue. Again, business planning is a great opportunity for recurring income, in part because of the inherent kind of annual filing type of nature that we have and the type of paperwork that's associated with a lot of business entities. Additionally, there's a greater volume of kind of routine type of work, contract review, general advice, little investigations, things like that. And so because of that, it's a much easier path for us to be able to create that maintenance plan for those of you who have kind of looked at maintenance plans for your estate planning practice but haven't quite gotten there yet. If you're already in the mindset of wanting to start one, adding a business planning practice is a great way to get some recurring income. The other thing that's great about this is that, and we're going to talk about this more at the end of the webinar, is that business planning can actually be a separate lead generation source for your estate planning practice. You'll be able to bring in more estate planning clients as you begin to work with more businesses. And again, there's a clear client tie-in. This lets us keep the work in-house rather than having to outsource or co-counsel, spread that work around, experience some of the issues that are associated with that. And I would submit to you that, the clients who already have these needs, they're going to have them fulfilled. And it might as well be by you. Clients that already know, like, and trust you, they've already worked with you for a will, a trust, or other type of estate planning engagement. These are the clients that already like you. So this is a really open and easy opportunity for you to fulfill these other needs, capture a greater amount of revenue, and more deeply entrench your relationship with your clients. So at this point, I'm going to hand it over to Jenny Villier for an overview of some of the entity selection decisions that have to be made when you're looking at business planning for your practice. Jenny, I've given you control of the slides.
Thank you, Patrick. So some of you may be wondering why we are talking about choice of entity. And the reason is, here in the business law group at WealthCounsel, we often get the question from estate planning attorneys who are looking to add business law to their practice, or folks that are, coming from some other practice area and would like to use WealthCounsel's business law tools for a business law practice. We get the question, where do I start? Where do I get started wrapping my head around the universe of business law and business law education? And the first place we typically point to is choice of entity. Having a good grasp of choice of entity and all the implications that are involved in what type of entity your client is using to operate and run its business is really fundamental to business law. So we selected choice of entity, and again, this is just a 30,000-foot view of choice of entity, and we have deep dives into this topic and many others available in our library of resources. So we're going to start by taking a look at the factors that drive a choice of entity decision for a business. But before we do that, let's take a step back and talk reality here. Most business attorneys do not have the luxury of having the choice of entity discussion with their clients at the outset. Clients arrive at the office having already formed an entity. Quite often it's an LLC, either using LegalZoom or some other form of do-it-yourself product. And they arrive at the lawyer's office when A, they realize that a mistake has been made, or B, they want to buy or sell assets, merge the business, bring in new owners, or any number of post-formation transactions. So most lawyers get that type of client, the ones that have already formed their entity and they're coming to you after the fact, not the ones that are just at the cusp of a new business idea and they engage a lawyer to help them from the ground up. But even in this situation, even where you're getting a client who's already formed an entity, understanding the implications of your client's choice of entity and potentially counseling them through an entity conversion, if that's appropriate, is a valuable skill for any business planning attorney. So we're going to run through the most commonly encountered forms of business entities. And again, if you're looking for a deeper dive, we've got lots of material in our library here at WealthCounsel. When you are talking to your client about choice of entity, there are a number of considerations that are important to them and that in some cases they may not be aware of or thinking about at all. Each of the different forms of entities have pros and cons by and large. Your client may be most concerned about management flexibility. They may be most concerned about tax implications and keeping their tax bill as low as possible. They may be most concerned about asset protection and limiting their liability exposure from the business operations. Costs sometimes are important to your clients, and this can be anywhere from nominal, depending on the form of entity and the jurisdiction, to very expensive, depending on the type of entity and the state law requirements for formation costs and ongoing compliance requirements. And then some entities have restrictions that make it impossible for your client to fulfill the structure that they would like or the capitalization. We're going to start with sole proprietorships. Now, these are by far the easiest entity that you will encounter, and that's because they're not an entity at all. This is a sole proprietorship exists when you have any person operating a business. So there's nothing involved in startup. It's the easiest one to start up. If you have a single client who starts a baked goods business and begins selling it for profit, they are running a sole proprietorship. Now, you will encounter these quite frequently because they are the most common form of business operation out there, a sole proprietorship. The opportunity for you as the business lawyer here is to talk with your sole proprietor client about the liability exposure of their business operations to help them determine if incorporating or forming a limited liability company may be appropriate. Now, for some businesses that have low risk exposure or perhaps don't have enough revenue to justify forming an entity for their business operations, a sole proprietorship could be just fine in that circumstance. But as the lawyer, it's our job to help our clients make sure that they understand the full picture, they understand their risk exposure and any benefits in perhaps changing the status of their operations and utilizing an entity that may provide them some protections that they're not familiar with. An LLC is the most common form of business entity out there. These were developed by the state of Wyoming. They came on the scene after partnerships and corporations. So for many years and historically, partnerships and corporations were the two primary forms of businesses. And there were a lot of great features about partnerships, and there were a lot of great features about corporations, but each one of them had drawbacks. And when businesses were formed and had to pick between a partnership and a corporation, they had to consider those drawbacks and decide what was most important to them. The LLC was developed to kind of create a hybrid form of business organization that took all the favorable aspects from partnerships and corporations and gave folks a new option which had none of the drawbacks of the partnerships and corporations that were their predecessors. So with an LLC, you can achieve limited liability for all your members. No longer is there a single member that needs to be on the hook as the general partner in a partnership. That general partner is liable for the partnership's obligations and debts. With an LLC, you don't need to have someone serving that general partner role. You also can achieve a great deal of flexibility that wasn't and isn't and continues to be not present with corporations, which are subject to numerous state law mandates. You have flexibility in taxation. You aren't pigeonholed into a single method of taxation when you choose an LLC. There's a number of options, and you can select and discuss this with your client to achieve their desired outcome. There is this idea of questionable asset protection for single member LLCs. So I said that with an LLC, you can achieve limited liability for all members. The caveat there is that there is this concept of piercing the veil, that it exists both in the corporate context and in the LLC context. And what that means is that while the general rule is that the owners have limited liability, they are not going to be held liable for the business's debts and obligations. The caveat is for situations where the court views the business as merely an alter ego of the owner itself. And in that case, they may pierce the veil to get to the owner and be able to satisfy the business's debts from the owner's personal assets. So you have to be careful with single member LLCs especially. Now the veil can be pierced with LLCs of any number of members, but with single member LLCs, it's particularly a potential risk for veil piercing, because with a single owner, it's much easier for that alter ego scenario to play out. So when you are representing a client that is a sole proprietor, and suppose they have a particularly risky business, and together you arrive at the decision to create a single member LLC. So I guess to make it, to bring more color to that, suppose you have a gentleman that runs a business that rents out those bouncy castles for children's birthday parties. And he's, a one-man show. He's got the equipment. He's a weekend warrior, books these parties and comes around and sets it up and then packs up and goes home. Relatively low revenue profile, and kind of a side business that he's been operating as a sole proprietorship. Together, you may discuss the fact that, there's significant risk and liability associated with a business like that, with injury potential, dealing with kids, and, the universe of potential liability is quite broad there. So together you arrive at the decision that, he should form a single member LLC. The questionable asset protection comes in if he does not run that single member LLC like a true business, a legitimate separate entity from himself, and a child suffers an injury, sues the LLC doesn't have enough assets to satisfy the debts. They pursue a veil piercing remedy, and because he doesn't have an operating agreement in place, he's been commingling his assets with those of the business. He has not kept any kind of minutes or other written records associated with the business. He doesn't have a separate bank account. Because of all those things, they can pierce the veil and get at his individual assets. And so in that case, of course, his whole purpose for forming the single member LLC is foiled, because he hasn't continued to take care of the entity in the way that he needs to in order to protect the asset protection component of the entity. So got a little long-winded there, but I think that's an important point to make. The operating agreement, I think this is another area of opportunity for business lawyers. Often, not all states require a written operating agreement. So you may get a client that comes in, they've already formed their LLC, they think that they're up and running, and they simply have a question about something else related to the business, and you review their facts with them and you realize they don't have an operating agreement in place. There's an opportunity there for us as business attorneys. Describing to them the risks associated with not having an operating agreement and the potential for veil piercing, you can help them understand why an operating agreement would be useful to have, even in the case of a single member LLC. I have a bullet here about series LLCs. Not going to spend any time there. The Model Series LLC Act was just passed late last year, actually mid-2017. So I surmise we're going to see more of these. We may get more questions from clients. The answer I would have for a client who asks me about a Series LLC right now is, let's wait and see how they play out. Right now, there's just not enough case law. They're just not recognized in enough states to really make me comfortable with using them. And I think using a number of LLCs right now can achieve the same result as using a Series LLC, and you don't have to take the risk of the various unknowns that are associated with Series LLCs. We've already talked about single member LLCs. Again, when you're operating a sole proprietorship, you've got unlimited liability for the business debts. So if liability protection is important to your client, then operating as an LLC is a way it's less expensive to operate as a sole proprietorship, but you're giving up that liability protection. Now we're going to move on. We've got a couple slides here on corporation. The thing to note, there is only one corporation. There's a state law corporation. The C and the S designations are tax designations. Those tell us how the corporation is taxed. A corporation is the state law entity. So you have to be familiar with your state corporate code to understand what the ongoing requirements are for corporations in that state. And then the S and C corporation designation is strictly a tax designation. So let's start with S corporations. I would say these are behind sole proprietorships and LLCs. S corporations are the next most commonly entity that I encounter with a small business practice. They are popular for a number of reasons. Now, they've got some limitations, however, but these limitations don't necessarily come into play for your client. I never encountered a problem with this limitations on ownership with the 100 or fewer owners. If your client knows at the outset they're not planning on growing this business to ever have more than 100 owners, that 100 or fewer owners limitation may be immaterial to them. You've also got a restriction that you cannot have a non-resident alien owner unless you use a special type of trust. So generally speaking, if you've got a foreign owner that you would like to bring into the business, you will not be able to elect S corporation status unless you use a special type of trust. What I want to focus on here, though, is this impermissible multiple classes of stock, because this does come up even with the smallest of businesses. When your clients are forming a business, I don't want to put a percentage on it, but it is very common for clients not to want all owners of a business to have equal economic rights. And if your client wants the owners to have different economic rights, they cannot operate as an S corporation because multiple classes of stock are not permissible. You can have differences in voting. So if your client is okay with the economics being equal, all distributions on a per share per day basis, but they would like to give certain owners voting rights and certain owners limit their voting rights, that is fine. It's just you cannot have multiple classes of stock and operate an S corporation. That's one of the fastest ways to blow your S corp election. And then I've got some tax bullets here. There are some special basis rules for S corporations, but that's really getting outside of the scope of our presentation today. Now remember that S corporations are really just state law corporations with an S election, and so you have to abide by corporate formalities, and these are state law driven. The benefit is the limited liability for all of your S corporation owners, and that goes for a C corporation too. All owners enjoy limited liability. One reason that you may see a small business electing to operate as an S corporation is for this self-employment tax. You may hear it referred to as a loophole. It's really just an opportunity, I like to call it. When you have an owner operating as an S corporation and they're active in the business, they can take advantage of the ability to designate a reasonable salary for their work, and any distributions they receive above and beyond that reasonable salary will be considered dividends to them, which will be taxed at a lower rate than the salary distributions. So some folks that are operating as an S corporation find that this self-employment tax opportunity provides a way to lower their overall tax bill. And then again, we've got some notes here on basis, and I'm not going to get into basis, but we do again have courses in our library that get into the taxation of all of these various business entities. And finally, we're going to talk about C corporations here. So again, we're just dealing with a state law corporation, and if you don't make any election, your corporation will be taxed as a C corporation. It takes a special election to opt into the S corporation taxation regime. So corporations generally get a bad rap because of this notion of double taxation. And double taxation is very real. Don't get me wrong. It's real. The corporation is taxed on the income when it's earned, and it's taxed at the corporate rate. And then when the corporation distributes dividends to its owners, they are then taxed on those dividends at their personal tax rate. So that's 2 layers of taxation. But for sophisticated practitioners, we can help clients plan around this double tax and determine if a corporation may still work for them, notwithstanding the double taxation feature. Some instances when corporations could still work would be if the business plans to retain or reinvest this income rather than distribute it as a dividend, because in that case, they're not subjecting themselves to that second layer of tax when it's distributed as a dividend. The second primary opportunity for reducing this or mitigating the double tax is when the corporation pays its owners a salary instead of dividends, because the corporation can take a deduction for that salary paid. So that helps to reduce the overall tax that is generated. So there are some real benefits to operating as a C corporation. Of course, all of the owners have limited liability. They're not going to be subject to liability for any of the business debts. With some exceptions, veil piercing does come into play with corporations, so the owners can be held personally liable in certain situations that lead to veil piercing. And also they cannot escape personal liability as a result of torts that they commit. So if there's fraudulent behavior going on with among the owners that is, leading to a corporate loss, the owners can be held personally liable as a result of that conduct. Some of the true benefits of C corporations, and this is where I primarily see C corporations, is in this notion of the ease of in transferability of the stock. So they're liquid. The ownership in a C corporation is much more liquid than ownership in an LLC or other form of entity. So sometimes businesses will choose to operate it as a corporation because they intend to have an IPO in the future, or they otherwise need to get outside investors who are by and large more comfortable with the corporate structure. So by forming as a C corporation, at the outset, it can help businesses that plan to do that kind of fundraising in the future. It can help them avoid having to change their form of entity down the road. But the biggest drawback is, again, you're subject to these state law requirements and formalities. So depending on your state law, there could be resolutions required for various decisions that are made throughout the year. Annual meetings could be required, minutes, financial record keeping. All of these would be dictated by the relevant state statute. I have just a couple slides on partnerships here. These are mostly for your reference. I would have to say, and Heather and Patrick, if it's different in your practice, I would love to hear. I just don't encounter partnerships very often when working with small businesses. And the reason is there is nothing that I can think of that a partnership could do for my client that an LLC could not. Where I still see partnerships coming up is in certain industries where folks are just used to partnerships. The one that comes to mind for me is private equity. They're used to partnerships. Investors are used to working with partnerships. They're all, used to the lingo and the key players with partnerships, and so they continue to use partnerships. But for the vast majority of cases, anything a partnership could do, an LLC could do with additional benefits. The additional benefits being, sorry?
Oh, Jenny, I agree with you there. The only other place I have seen them is in real estate. You'll see them in some real estate things, limited partnerships. And then obviously, many of our attendees today are estate planners. The family limited partnership, of course, that was the classic structure. So you'll see them a lot there as well. And that may be why there's a familiarity among our audience. But for the most part, I think I agree with you. I think they're obsolete for most purposes, and people have kind of moved to the LLC form.
Yes, and thank you for pointing that out. I should have said, I don't think Monica mentioned at the outset, I am not an estate planner. I have I'm learning estate planning, but I am a business lawyer through and through, so I forget about the uses on the estate planning context, and thank you for mentioning those. So when you encounter a partnership, there are a number of varieties of partnerships that you could encounter, and this is driven by state law as well. You may have seen LLLPs, LP, any number of designations. We're going to focus today on general partnerships and limited partnerships and just touch on the key differences and similarities. Your general partnership is essentially the cousin to the sole proprietorship. It's the entity, and I say that in quotes, that exists when two folks are running a business together and have no agreement in play. They simply start running a business. They are a general partnership. Similar to, you have a single client that starts running a business, he is running a sole proprietorship. So the general partnership is what exists by default. So it's obviously easy to form and inexpensive. The drawback, of course, is that you've got unlimited joint and several liability for all the partners for all the partnership liabilities. That is why typically folks would move into the limited partnership regime. And by operating a limited partnership, you have to designate one partner as a general partner, and the rest of your owners can be limited partners, meaning they get to enjoy limited liability. But of course, you have that one partner that is going to be on the hook for all the partnership's liability. So that is, something that is something that many clients want to avoid, and that's when I would steer them to a limited liability company. A limited partner, as I said, a general partnership can be formed simply by starting business operations. A limited partnership can only be formed by doing a filing and creating an agreement, because you have to have notice to the state that you are forming a limited partnership. You need to provide notice to third parties by adding the LP designation to your name of your business entity. But by kind of jumping through those hoops, you get to enjoy limited liability for the limited partners with the one general partner who's going to be personally liable for the partnership debts. Management in a partnership setting depends on whether it's a general partnership or a limited partnership. In a general partnership, all the general partners share in the management responsibilities. In a limited partnership, the limited partners are typically more akin to a passive investor, with the general partnership having more of the managerial role. Profit and loss sharing with a general partnership, again, it's profits are shared equally among the partners. Everything is thought of equally. You've got joint and several liability among the partners. The profits are shared equally regardless of contributions. The default rule for a limited partnership is that the profits and losses are going to be shared in proportion to the partners' contributions to the partnership. So that was the 30,000 foot view of business formation, and now we're going to get to the good stuff. How do you start to make money off of the business planning practice that you're starting?
Right, so I lucked out here. Good morning, everyone. I'm Heather, and I'm the Director of Business Law at WealthCounsel, and I'm also a business development lawyer, not unlike Jenny. So I work with my clients and with our WealthCounsel members to help develop the business law side of their practices. And a little bit like Patrick, I came to WealthCounsel because I was a business lawyer that was looking to add estate planning onto my practice. And so I think there are some things that are really instructive in terms of what you can take from your estate planning practice and apply to a business practice that really work out well. All right, so let's get started. So I get the fun part, increasing your firm's revenue. Right, we're talking about taking off your estate planner hat and looking at the business law side of your practice a little bit differently, and then getting to show your creativity, right? Designing your service offerings in a way that makes you happy, in a way that makes your clients happy, where you feel like you are really having an impact on their businesses and their happiness, truly. Pricing structure for your business, and then some operational considerations. All right, so talking about increasing your firm's revenue. And let me just expose all of these bullet points here. So really there are a couple of ways that we're talking about increasing our revenue, right? We're talking about adding a new revenue stream, and we're also talking about increasing the ROI, so the return on investment, for each of your clients that you've got on the estate planning side. Because as we all know, it's so expensive to acquire these clients that we want to make sure that we are not leaving money on the table or leaving services unoffered to clients that can help them in their lives and in their businesses. So we've got upsell opportunities, less revenue leakage to co-counseling or paying outsourced providers. So I'm not sure where everybody is located, but I can tell you I am located in a small town, a small mountain town with not a huge population, and I not only get a lot of competition from general practitioners, but I also get a lot of competition from CPAs who like to practice law here in this area. And so, you know, what we're looking to do is to keep those clients, keep a lot of that revenue that we would otherwise be handing out in a practice area that pairs up really nicely with estate planning, right? Maintenance plans we can touch on a little bit, and the function of outside in-house counsel. So the nice thing about business law is that there's just so many different ways that you can practice it, and you can slice and dice it however you like. You can focus on just the business planning. You can do business planning as well as representing the business as an ongoing concern. You can add litigation if that's something that you would like to do. I did not litigate. Jenny, I don't think you did much litigation either, did you?
No, I did not.
Mm-hmm. And so, and a lot of my other business development and business planning colleagues, we tend to hand those pieces out to litigators, but we very often manage that process on behalf of our clients. All right, so taking off our estate planning hat, I'm going to actually pass this back over to Patrick for a moment, because Patrick is our resident estate planner here to talk a little bit about, and I believe, Patrick, you also did business. You had business planning services as in your practice?
Yeah, we did offer some of those, and you know, I included this because I think it's important for us to remember when we're looking at this practice area and adding it, that the way we've approached entity formation and the usage of kind of business tools from an estate planning perspective may not work for our business representation matters. And so the thing I like to do is think about, you know, kind of taking off my estate planner hat, because when I'm using an LLC in an estate planning engagement, I'm kind of using it one way. But then if I have unrelated people coming to me and they want to form a furniture store or a bakery or a restaurant or whatever type of business they're going to be opening, that's going to be very different, the way that the questioning, the way we're going to approach that. So we have to make sure that we are aware of kind of what hat we're wearing, and that ends up being so important in the way that we end up talking about the way we do our services, the value we're offering those clients. And it's also important because the tool that we're selling or that we're really promoting to these people, to our business clients, is really the value they're getting. The things they perceive of as important are different than the things that our estate planning clients perceive of as important. So usually in my experience, it was access. They really wanted to be able to call, get quick questions answered. They were often concerned about being sued in a much more sort of ever-present way than many of our estate planning clients were. And then importantly, there ended up being a lot more what I call adverse parties. They weren't really purely adverse because we didn't do litigation either, but they were people that might become adverse. They certainly weren't aligned. In estate planning, we kind of think of the family as aligned together. Everybody's kind of on the same team. In a business engagement, they're not. I mean, we've got ourselves and then we've got the landlord. We've got ourselves, the other side of the contract to the party. We've got employees, vendors, all of these other potentially adverse parties. And so, being mindful of that when you're working with the client is important, because their perspective is that that's the other side. And if you're not on that same wavelength, it can be tough to relate to the client.
Yeah, so true. All right. So now the part where you get to shine, designing your service offerings. Right, so there's a couple of different ways that you can design your services, and you should also be looking at how are we talking about increasing this revenue? There are two models. I'm sure there are more, but there are two biggies that stand out in my mind. The first is we can increase revenue by improving our engagement rate, right? So I've got a certain, let's say, a flat fee structure, and I'm engaging 90 to 100% of the clients that are walking through my door. That's one way. Or I can increase my revenue by engaging higher value clients, even if my engagement rate is not quite as high. So if we take a look at designing our service offerings through that lens, we can see that we can fit all of these pieces into one or the other and potentially both, right? So you can have a transactional focus where, let's say, if you were focusing on entity formations, then your job with the client, if that's what you want, can end once that entity is formed. That gives you a lot of flexibility in terms of whether or not you want to continue working with that particular client. Or you can have a different relationship-based or maintenance focus with those clients, where not only do you handle the entity formation, or as Jenny said, and was true for my practice as well, most of my clients came in with an entity already formed, usually through LegalZoom or a different online legal warehouse. And we took those businesses and created relationships where we were really serving as outsourced or outside in-house counsel, where we would have different types of packages and plans that we'll talk about in a second, and really cultivating that relationship so that we became the go-to counsel for those businesses, not just on entity formation or tax issues, but really on things like employment issues, IP issues, and a lot of business organization issues as well. So you can design your services, using packages or tiers. I personally had a VIP plan that was multi-tiered, again, that we'll talk about in a second. And the caution here is that once you design those services, it's really important about being clear about what's in each of those tiers or in each of those packages, so that you don't have a situation where your clients are taking advantage of you, or have a situation where you don't feel that you're being adequately compensated for the work that you're doing. Maintenance plans for business entities. So maintenance plans or VIP plans, subscription plans, whatever you would like to call them, it's a very natural proposition in a business law practice because there's so much ongoing work for those businesses that needs to occur, not just the annual filing requirements with the Secretary of State and the minutes and meetings and maintenance of records, but really there are very often small issues that come up. So on-call type of questions, or as I called them in my practice, quick questions. So my classic quick question was the Friday afternoon at 4 p.m. call where a client would want to fire somebody before the weekend, and talking through whether or not that was a good idea in terms of the risk that would attract. Or things like we've got in this last bullet, I got this IRS or Department of Labor letter. As we know, there's lots of scams going on right now. I would get calls from clients saying that they received letters from overseas IP portfolio companies, and where should they send their $4,000 to ensure that their trademark was going to be protected overseas. So all of that, we don't realize how little sometimes our clients who might be very adept at their businesses understand about some of the legal aspects or how to protect their assets, such as their intellectual property rights, what they can or can't do with employees. And so these types of quick questions are really important to ensuring that they're adequately covered for risk. All right, pricing strategies. Business law is one of those areas where you really can create a pricing structure that works best for you and your clients. It's extremely flexible. So you can go with the traditional hourly, so pure hourly billing that puts all of the risk on the client. Of course, we as lawyers love that. I loved it, I'll say personally. But clients don't love it so much. It's really difficult for them to control their costs and to manage their own risks. So billing blocks, this is where you sell, let's say, a block of hours in a month, and it's a use it or lose it proposition. Typically, we'll sell those at a significantly discounted rate. Or you could do fixed price. You could do a hybrid, which is what I did in my own practice. So fixed price plus hourly. So let's say we create a contract for a fixed price, and then any negotiation that occurs thereafter would be on an hourly basis. All of these can work well so long as you're managing it adequately and you've got a clear idea and you've set clear boundaries and expectations with your clients. So some bullet points here about should I offer bulk discounts? I did. That's a question that you can answer for yourself. But again, the issue here is about being flexible, and business law really lends itself to the ability to be flexible with your pricing. And then some operational considerations. So without going into these too far, we're talking here about setting up processes in your practice that will help automate a lot of the work that you have. So processes and operations for entity formation, contract administration, you know, this is a practice area that lends itself really well to checklists and questionnaires and a number, you know, of other ways of communicating in an automated way with clients, much of which we offer through WealthCounsel. Lots of checklists, lots of different ways that you can communicate with your client that helps you keep them in the know and keeps that relationship ongoing. So some other operational considerations, your legal knowledge, okay, what technology you and your staff might need to invest in. And remember that estate planning will probably have separate operational issues. There is some crossover, but just doing an inventory of the things that you might need is a really good way to start. So I'm going to leave you with this thought. One of the great things about business law is that for all of your clients, you've got something in common, because I suspect that most, if not all, of the practitioners that we've got on the call here today are operating their own business. And so that's something that you've got in common with those clients. And so the things that you learn about operational excellence for your own practice is something that you can help counsel your clients on. And it's a real value to them and that can help them grow their business and be set up to take advantage of opportunities as they come down the line. So that was a quick overview about designing your service offerings, and I'm going to pass it now back to Patrick to talk about the big T's, how to find those clients.
Thank you, Heather. And that is a great point that you make there about the fact that so many of our listeners today and members of WealthCounsel you guys are small businesses too. So learning some of these things and then being able to share that wisdom that you've accumulated from just running your own practice, it's such a natural fit in a practice area. And apologize for the background noise. We're actually, we have kind of a line of thunderstorms here moving through. So forgive me for the rain and thunder if you can hear that. So let's talk here on the moving into kind of how to sell what you're offering and find those clients. And so these are the four kind of topics I want to briefly address on during the closing few minutes of our webinar. Let's just jump right in. So cross-selling is, you know, really selling different but complementary services to existing customers or clients. This is really frequently the place where many estate planning attorneys and other attorneys with existing client bases will start. And so the way that works is, you know, we've got those former estate planning clients that have entities, right? We all have them. Even people who have those family partnerships, family LLCs, they still might need and benefit from some maintenance if we haven't been doing it. And what we can do is we just offer to work with those having already kind of finished the estate planning process for that client. And so I want to walk you through just a quick process that you can use to get that started in your practice, because I know the idea of that is something that many of us have thought of. That's not revolutionary, but sometimes the implementation can be a little bit tough. And so I just want to kind of walk you through this simple process you can use. First step would be to just identify those former clients that have LLCs, corporations, partnerships that are closely held, for which they maybe would benefit from some legal work on their entity. And again, these can be those operating businesses, which is where I think Heather and Jenny's experience primarily is. It could be real estate entities, holding companies, family entities, anything that is one of these entities that might need some work. The next step is to really send some information, again, describing some of the issues that can happen with poorly or improperly maintained entities. So this is just bringing that awareness to these clients that, hey, you know, setting up your LLC was not just going and filing the paperwork with the Secretary of State and then you're done. There's things that have to be done to make sure we protect that liability shield. There have to be things that are done to make sure that we're preserving tax elections, all of these kinds of things, and really sharing that information either via mail or email. One of the great things here is, Heather and I were talking before the call, is that inside of business law, we have a lot of resources to help you with this. So it's not like you have to create this from scratch or sit down and block off a couple of days to work on this. We have a lot of these resources available for you. So you have to compile your list, but once you've compiled that list, we really have a lot of this information available to you on the member website. Then the third thing you would want to do is, and this is such a critical piece of the process here, is call those clients for follow-up. You know, I always thought to agree to a complimentary review. So I would say, you know, we'd send them that information, and then I would actually pick up the phone and we would, you know, dial a certain number of people every day, and we would say, we would love you to come in. We want to talk about ABC LLC, and you know, how does next Tuesday at 3 o'clock work for you? And what we would want to do is do that complimentary review to kind of take that general information that we had already sent them and really tailor it to their particular situation, to kind of show them some of the risk that they have by not maintaining their entity properly, and hopefully get that engagement. Now, the other strategy, selling strategy, that I want to talk about here is called upselling. Now, upselling is different than cross-selling. This is really when we're selling something that's either more expensive, more in-depth, or some other kind of add-on during a selling experience. Now, this is a different technique. This is something we would use with maybe a new estate planning client who's come in. So we have that new client who's come in, maybe they have an LLC, maybe they have a sole proprietorship, a closely held corporation, some other type of thing. And the goal here for us is to get that estate planning engagement, but also get the business engagement. So we're managing to sell both to those clients. Now, the process we would want to use here is a little bit different, and I'll walk through why it's a little bit different. So one of the things we'd have to do is we're still kind of in that building, that know, like, and trust building with a new client. So we need to make sure we're focused on that. But we need to actually kind of think about our estate planning engagement and consultation and figure out what operations, business operations or ownership the client has. Couple of ways you can do that. I always liked getting tax returns. You know, if they've got a Schedule C, that means they've got an LLC or a disregarded entity. They're a sole proprietor. Schedule E, we can see their partnership or S-corp holdings. You know, Schedule E, we can find out whether they've got some rental property that might benefit. We can also look in public filings, see if they've formed any LLCs. Go check them out on LinkedIn and other social media. Do they list themselves as owner, partner, you know, manager, some kind of title that would denote that maybe they have an ownership stake in the company? Great thing, and it gives you a chance to just kind of ask them about that. And again, you can always just ask the client. You can say, hey, do you own any LLCs? Do you have any of this stuff? Typically, people will know those things. Now, after you've highlighted some of those things, you want to go through the risk profile. In many cases, many of you that are listening today probably are thinking about it from an estate planning lens. And what I would encourage you to do here is, as you've added business planning to your practice after today's webinar and you've gotten started with that, I would submit to you that it's a good idea to, when you have these engagements where you're trying to do this upselling and you've noticed that there's an unmet business need and there's an unmet estate planning need, ask the client which is more important to them right now. It may be that they came in for some estate planning, but after they've kind of explored some of the business issues, that might be more important. And so then what really the third step is just to move forward with the most pressing engagement. It may be that they came in to get a will or a trust done, but in fact, they're actually more concerned about that other issue, but they didn't know you could help with it. In that case, help with that, backlog the other one, but make sure you get them to sign up for both services at the same time. All right, so let's shift gears here a little bit and talk about, instead of selling these things to people once we have them in the office, we need to get people in the office. There's really kind of two tracks here, similar to what we would have for an estate planning practice. We can either go direct to the public, direct to clients. We can also take a center of influence or referral-based kind of strategy. So let's talk about direct to the public. Everybody is familiar with these things. We've got workshops, entrepreneur meetups and industry meetings, direct mail, internet marketing types of strategies. The bottom line here is, and we all know this from our estate planning practices, but it's important to kind of redo this work for our business planning practice. We need to use content that's relevant to our ideal client. So we need to know who our ideal client is. What are the businesses, the business types that we're really wanting to target? What would be things that would be very relevant to them and the concerns they have? And let's use that type of content. We can't simply just take estate planning content or slightly tweak that. It really needs to be tailor-made for our purposes here for marketing to our business clients. But the great thing is that many of these techniques, many of these strategies, the skills that we've developed working on these things for our estate planning practice readily translate over. It's just the messaging is different. So if we're already good at direct mail, if we're already doing some internet marketing, it's literally just changing the message, changing maybe where we do some of the promotion, but the skills we've already built on a lot of these marketing things readily transfer over. So that's great news. And then when it comes to centers of influence, they're different than they are for estate planning. At least in my experience. There is some overlap again with some financial planners, but you want to get in with those CPAs, business coaches, consultants, bankers, insurance brokers. These are the centers of influence that can refer people into you that need the business planning. Now again, they may be different, but many of the strategies, again, like the direct to the public type of things, the tactics are the same. We're going to want to invite people to events. We're going to want to send them newsletters. Lunch, coffee, cocktails, whatever is appropriate and that we feel comfortable doing for those networking types of purposes. And again, just kind of a reminder about general networking, but we need to demonstrate value to them, the other professional, and to their clients. It cannot be about us. It can't be about what we're getting out of the engagement. It's obvious that we're trying to get a client. We need to be able to show how it is that we're going to be able to help that center of influence and how we're going to be able to help the referrals that they send to us. And then, of course, once we get a referral in the office, we need to deliver value to those referrals. We need to do great work for them, make sure that they're fulfilled and happy, and that they can report back to the person who referred them to us that we did great work. One of the great things here, and we talked about this at the beginning of the webinar too, is that this can go the other way as well. In much the same way that we want to bootstrap our business planning practice through our estate planning practice by cross-selling, we can do the exact thing kind of in reverse when it comes to building our estate planning practice. Client that comes in needing business work, well, they probably have unmet estate planning needs too, so that's that cross-selling in the other direction. Now again, this may not be immediate, but with reminders, some dedicated effort, you can really use this business planning practice that you're going to be able to bootstrap from your estate planning practice to go back and kind of feed back in to building your estate planning practice as well. So here with, looks like we're right about out of time. You can look through these final thoughts, but one of the things I do want to share with you though is that WealthCounsel and our business law subscription really do position you for success by giving you the tools that you need to learn about the law through our thought leadership and CLE, and really the community that you need to be able to co-counsel where appropriate, get helpful answers, bounce ideas off of, and then again, Business Docs really gives you that ability to efficiently prepare documents. That way you're going to be able to spend time on the parts of representing your clients that are important and that the clients truly value. You can gain more insights at wealthcounsel.com, and again, when you're there, double check that resource center to access additional information about all of our different products, including our business law subscription. So again, if you need more information, please give us a call, 888-659-4069, extension 819. You can also visit us online at wealthcounsel.com. It looks like we are actually at the top of the hour, and any of the questions that came in that we weren't able to address, we will get those answered to you via email. I hope everybody has a great rest of their Tuesday, and please do remember to fill out our program survey that you will see pop up on your screen right after the webinar is closed. Thanks, everybody.